Acquittal. Judgment that a criminal defendant has not been proven guilty beyond a reasonable doubt. Affidavit. A written statement of facts confirmed by the oath of the person or party making it. Affirmed. Judgment by appellate courts where the decree or order is declared valid and will stand as decided in the lower court. Alford plea. A defendant's plea that allows him to assert his innocence but allows the court to sentence the defendant without conducting a trial. Such a plea is often made for purposes of negotiating a deal with the prosecutor for lesser charges or a sentence. Allegation. Something that someone says happened. Answer. The formal written statement by a defendant responding to a civil complaint and setting forth the grounds for defense. Appeal. A request made after a trial, asking another court, usually the Court of Appeals, to decide whether the trial was conducted properly. Appellate court. An appellate court has the power to review the judgment of another lower court or tribunal. Arraignment. A proceeding in which an individual who is accused of committing a crime is brought into court, told of the charges, and asked to plead guilty or not guilty. Arrest warrant. A written order directing the arrest of a party or person. Bail. Security given for the release of a criminal defendant or witness from legal custody, usually in the form of money, to secure her appearance on the day and time appointed. Bankruptcy. This refers to statutes and judicial proceedings involving persons or businesses that cannot pay their debts and seek the assistance of the court in getting a fresh start. Bench trial. A trial without a jury in which a judge decides the facts. Beyond a reasonable doubt, a standard required to convict a criminal defendant of a crime. Brief. A written statement submitted by the lawyer for each side in a case that explains to the judge why they should decide the case, or a particular part of a case, in favor of that lawyer's client. Capital offense. A crime punishable by death. In the federal system, it applies to crimes such as first-degree murder, genocide, and treason. Charge. The law that the police believe the defendant has broken. Charge to the jury. The judge's instructions to the jury concerning the law that applies to the facts of the case on trial. Circumstantial evidence. This refers to all evidence that is not direct evidence, such as eyewitness testimony. Complaint. A written statement by the plaintiff stating the wrongs allegedly committed by the defendant. Continuance. A decision made by a judge to postpone trial until a later date. Contract. An agreement between two or more persons that creates an obligation to do or not to do a particular thing. Conviction. A judgment of guilt against a criminal defendant. Counsel. A term used to refer to lawyers in a case. Counterclaim. A claim that a defendant makes against a plaintiff. Cross-examine. Cross-examine is the questioning of a witness by the attorney for the other side. Damages. Money paid by defendants to successful plaintiffs in civil cases to compensate the plaintiffs for their injuries. Default judgment. A judgment rendered because of the defendant's failure to answer or appear. Defendant. In a civil suit, the person complained against; in a criminal case, the person accused of the crime. Deposition. An oral statement made before an officer authorized by law to administer oaths. Direct evidence. Evidence that supports a fact without an inference. Discovery. Lawyers' examination of facts and documents in possession of the opponents before trial to help the lawyers prepare. Docket. A log containing brief entries of court proceedings. Evidence. Information presented in testimony or in documents that is used to persuade the fact finder, judge or jury, to decide the case for one side or the other. Exculpatory evidence. Evidence which tends to show the defendant's innocence. Exhibit. Physical evidence or documents that are presented in a court proceeding. Common exhibits include contracts, weapons, and photographs. Felony. A crime carrying a penalty of more than a year in prison. Grand jury. A body of citizens who listen to evidence of criminal allegations, which are presented by the government, and determines whether there is probable cause to believe the offense was committed. Habeas corpus. A written order that is often used to bring a prisoner before the court to determine the legality of his imprisonment. Hearsay. Statements by a witness who did not see or hear the incident in question but learned about it through second-hand information such as another's statement, a newspaper, or a document. Impeachment. The process of calling something into question, as in impeaching the testimony of a witness. Inculpatory evidence. Evidence which tends to show the defendant's guilt. Indictment. The formal charge issued by a grand jury stating that there is enough evidence that the defendant committed the crime to justify having a trial. It is used primarily for felonies. Forma pauperis. Permission given to a person to sue without payment of court fees on claim of indigence or poverty. Information. A formal accusation by a government attorney that the defendant committed a misdemeanor. Initial hearing. Court proceeding in which the defendant learns of his rights and the charges against him and the judge decides bail. Injunction, an order of the court prohibiting or compelling the performance of a specific act to prevent irreparable damage or injury. Interrogatories, written questions asked to one party by an opposing party who must answer them in writing under oath. Interview, a meeting with the police or prosecutor. Issue, the disputed point in a disagreement between parties in a lawsuit. Judgment, the official decision of a court finally determining the respective rights and claims of the parties to a suit. Jurisdiction, the legal authority of a court to hear and decide a case. Juror, a person who is on the jury. Jury, person selected according to law and sworn to inquire into and declare a verdict on matters of fact. Jury pool, the group of people from which the actual jury is chosen. Jurisprudence, the study of law and the structure of the legal system. Lawsuit, a legal action started by a plaintiff against a defendant based on a complaint that the defendant failed to perform a legal duty, resulting in harm to the plaintiff. Litigation, a case, controversy, or lawsuit. Magistrate judges, judicial officers who assist district court judges in getting cases ready for trial. Misdemeanor, a petty offense, a less serious crime than a felony, punishable by less than a year of confinement. Mistrial, an invalid trial caused by fundamental error. When a mistrial is declared, the trial must start again, beginning with the selection of a new jury. Motion, attempt to have a limited issue heard by the court. Nolo contendere, a Latin term meaning no contest, has the same effect as a plea of guilty as far as the criminal sentence is concerned, but the plea may not be considered an admission of guilt for any other purpose. Oath, a promise to tell the truth. Objection, a protest by an attorney, challenging a statement or question made at trial. Opinion, a judge's written explanation of a decision of the court. Oral argument, an opportunity for lawyers to summarize their position before the court in an appeal and also to answer the judge's questions. Panel, in appellate cases, a group of judges, usually 3, assigned to decide the case. Parties, plaintiffs and defendants, petitioners and respondents to lawsuits, also known as appellants and appellees in appeals, and their lawyers. Plaintiff, the person who files the complaint in a civil lawsuit. Plea, in a criminal case, the defendant's statement pleading guilty or not guilty in answer to the charges in open court. Plea deal, or plea bargain or agreement, an agreement between the defendant and prosecutor where the defendant pleads guilty in exchange for a concession by the prosecutor. Pleadings, written statements of the parties in a civil case of their positions. Precedent, a court decision in an earlier case with facts and law similar to a dispute currently before a court. Procedure, the rules for the conduct of a lawsuit. There are rules of civil, criminal, evidence, bankruptcy, and appellate procedure. Preliminary hearing, a hearing where the judge decides whether there is enough evidence to require the defendant to go to trial. Pre-trial conference, a meeting of the judge and lawyers to discuss which matters should be presented to the jury, to review evidence and witnesses, to set a timetable, and to discuss the settlement of the case. Probable cause, an amount of suspicion leading one to believe certain facts are probably true. Probation, a sentencing alternative to imprisonment in which the court releases convicted defendants under supervision as long as certain conditions are observed. Pro se, a Latin term meaning on one's own behalf. In courts, it refers to persons who present their own cases without lawyers. Prosecute, to charge someone with a crime. Public defenders, represent defendants who can't afford an attorney in criminal matters. Record, a written account of all the acts and proceedings in a lawsuit. Remand, when an appellate court sends a case back to a lower court for further proceedings. Reverse, when an appellate court sets aside the decision of a lower court because of an error. Search warrant, orders that a specific location be searched for items, which if found, can be used in court as evidence. Sentence, the punishment ordered by a court for a defendant convicted of a crime. Service of process, the service of writs or summonses to the appropriate party. Settlement, settlements often involve the payment of compensation by one party in satisfaction of the other party's claims. Statement, a description that a witness gives to the police and that the police write down. Statute, a law passed by a legislature. Statute of limitations, a law that sets the time within which parties must take action to enforce their rights. Stay, a temporary pause or suspension of a judicial proceeding. Subpoena, a command to a witness to appear and give testimony. Subpoena duces tecum, a command to a witness to produce documents. Summary judgment, a decision made on the basis of statements and evidence presented for the record without a trial. Temporary restraining order, prohibits a person from an action that is likely to cause irreparable harm. This differs from an injunction in that it may be granted immediately, without notice to the opposing party, and without a hearing. Testify. Answer questions in court. Testimony. Evidence presented orally by witnesses during trials or before grand juries. Tort. A civil wrong or breach of a duty to another person as outlined by law. A very common tort is negligent operation of a motor vehicle that results in property damage and personal injury in an automobile accident. Transcript. A written, word-for-word record of what was said, either in a proceeding such as a trial or during some other conversation. Trial. A hearing that takes place when the defendant pleads not guilty, and the parties are required to come to court to present evidence. Verdict. The decision of a petit jury or a judge. Voir dire. The process by which judges and lawyers select a petit jury from among those eligible to serve. Voir dire is a phrase meaning to speak the truth. Witness. A person called upon by either side in a lawsuit to give testimony before the court or jury. Writ. A formal written command, issued from the court, requiring the performance of a specific act. Writ of certiorari. An order issued by the Supreme Court directing the lower court to transmit records for a case for which it will hear on appeal. Thanks for watching. If you enjoyed this video, consider subscribing to my channel for more informative content every week.